give it a minute because people need to like, oh, here we go. We got participants. Okay. Let's give it about 2 minutes and we'll get started.
All right.
As our attendees slowly pour in. All right, we're getting a good segment.
And I'll also talk about layoffs and about the CHIPS bill.
Excellent. All right.
I think that's a solution to the problems we were talking about, actually.
Yeah.
Yeah.
Not Eagle, but the CHIPS bill. Yeah.
Okay, I think it's time to get started. Welcome, everyone. We've got an exciting event today between SABA North America's immigration section and our advocacy committee. And I'm happy to introduce those who do not need much introduction today. Ira Kurzban, who's the guru of immigration, and obviously one of the sources of, a really great source for SABA North America as we come up on Advocacy Week that's happening from April 24th to 28th. And so this is the first program we have in this series, and it'll be focusing on immigration because that's one of our core issues for the Advocacy Committee this year. And luckily, we have the help of two of our co-chairs of the immigration section today, Mala Bajpai and Rohit Biswas. And so without taking any more time, I'm going to turn it over to Mala, Rohit, and Ira, the incredible Ira, so we can get started and get to learning.
Thank you, Tara.
Thanks, Tara. So just to give our participants a little bit of background, this whole webinar and kind of series came about because we all read about all these visa backlogs and all the issues facing our community. And we wanted to know how SABA can help, not just attorneys, but also our community as a whole. There's lots of statistics about the significance of the South Asian community in the US. I used very reliable resources on ChatGPT and TikTok that told me many statistics, like we're 1% of the population, we pay 6% of the taxes. But it seems like our immigration system, which is kind of designed so not one country or area can benefit, it seems to be like one country or area is really being punished. And there's a lot, I mean, I'm kind of a troll on all of these like Facebook groups about immigrants, and it's really affecting, I think, the psyche of a lot of South Asians who have kind of done what they can do and they're just waiting and they feel like they're never going to get a green card and they're somehow being punished for where they're from. So that's kind of how this came about. And we turned, of course, to the guru, Ira Kurzban, to teach us how we can help and what light there is at the end of the tunnel, if any. So Rohit, do you want to?
Yeah, so, thank you so much, Mala, for that introduction. It was great. And one of the numbers that jumped out was 1% of the of the population and 6% of the taxes, you said.
Mm-hmm.
And so that seems just proportionate to the years and years of waiting for green cards for Indian nationals. I think Ira, and you will definitely say a lot more about this in a bit, but I think even 30, 40 years ago it was a little bit easier to get a green card if you were born in India and coming here. I know my parents are like, what's the problem? It's fine. I have a green card. I was a US citizen. Like, why is this a big deal? Like, why are you droning on about this? It's different now. Obviously, there's country quota. So 7% of the green cards that are issued are allocated to each country. What does that mean? 7% of what? Ira's going to go into that. Each month, there's a visa bulletin that's published that tells you approximately how long the wait is. And that doesn't help us at all either, because that doesn't give us a wait, because the next month the bulletin can change. How is that bulletin done? That's why we have Ira again. A lot of these questions, Wall and I, and we've been practicing for years, it's just this nebulous thing of these waits for people born in India that it's frustrating because you can be stuck in a job or a situation for years and years and years, 10 years, 20 years, with no end in sight. So we kind of want to, one, have Ira educate us today on that, and two, see what can be done in kind of the advocacy sphere for this. So with that, Ira.
Wait,
take it-
hold on. I forgot to do the disclaimer.
Oh, yes.
This
That's
webinar constitutes legal advice. This is just for information purposes only. Okay, go ahead, Ira.
Thank you.
Great. I'd love to hear that. Okay. So I have to say, after practicing years and years and years, I've never fully understood the worldwide quota system. I think I now have a good handle on it. So I'm going to impart whatever I know to everyone listening to this webinar, because I think the starting place has to be, what are the numbers? How are the numbers function? Why is there a special quota that seems like a special quota for Indian nationals and not? So the worldwide quota system, as you know, is generally divided into employment-based and family-based. The family-based is 480,000 visas available. The employment-based is 140,000 visas available. Diversity visas also encompass 55,000. So there's really three separate groups. So let's take the family-based first. The family-based, the 480,000 visas is what they call a pierceable cap, meaning you cannot go below 226,000 visas for the various categories of EB1 through EB5. The remainder of that 440 can be exceeded. In other words, most of the visas that come to where people get them from whatever country they come from are immediate relatives. They actually exceed, if you took 226,000 and you added the immediate relatives, it would exceed 480,000. So what Congress did is basically say, no matter how many immigrant immediate relatives there are, we will not give less than 226,000 for family preferences. Okay, unlimited numbers immediate relatives, 226,000 for family preferences. And therefore the 480,000 number, even though you often hear it, really doesn't mean anything anymore.
Mhm.
Because we have so many more immediate relatives when you add them with the 226. So the 226 is the number when you're talking about family-based quota systems.
So it can't go.
Everybody got that?
So it can't go above 226. So if you're the principal applicant, it couldn't be only one 226, 226 times, 226,000 times. Is that what you're saying?
Well, actually, as you know, because of derivatives, it's not necessarily the one person, right? This is the issue I was bringing up, for example, I think when we talked the last time, EB5,
right?
You would think with the country quotas and so forth and the overall quota, it would be 10,000 visas a year for 10,000 investors. But in fact, it's not. It's only about 3,300 investors, then their family members, because each family member gets a visa. Right. And I've been, one of the things, hopefully we'll talk about a little later, is this strategy, how we get them to change the system so that the derivatives do not count. In other words, what you were suggesting is how it really should be, which is one visa for the family. Not one visa for my spouse, not one visa for each of my 5 children. So all of a sudden we now have, 7 visas being used up.
Yep.
And that has, to give you an idea of how enormous that impact is, we litigated this issue and the government litigated it unsuccessfully, I may add, unfortunately, but the government conceded that if there was a statutory change, there'd be hundreds of thousands of more visas each year.
Is that our number one point for Advocacy Week for South Asian Bar? I think
I
so.
think that's a big point. I mean, we'll talk about some up, but I think that is talking about ending derivatives. Now, even some Republicans have come forward in suggesting they should end counting derivatives, but only on the employment side. They don't want to do it on the family side for political reasons, obviously, but some have talked about doing it on the employment side. So that is a big issue, how we end derivative counting. Okay, so the 226 is divided not by percentages, but by actual numbers. So, and the thing that's most important of all the numbers, this 226, the group that has the largest number is FB4. That's brothers and sisters. Okay. And why does that have the largest number? Again, it was a political reason. Congressman Waxman in the House at the time wanted to get more visas to Asia. And he knew that there were many people who tried to bring over their family members, their brothers and sisters. The problem with that number of the 226, 65,000 go to FB4. The problem with that number is it's inexhaustible. You know, it's easily exhaustible, which is why you have these huge backlogs. I mean, you look at Mexico. If we look at Mexico right now, right, in EB, in family-based, let's see, Mexico's back to April 1st of 2001.
Wow.
So I want to bring my brother or sister over, it's 22 years. India is backed on F4 to February 22nd, 2006.
Wow.
Which is almost 17 years, right? And China is pretty close behind, probably with 15 years. So the problem is there just aren't enough visas, and it's hard to imagine how many visas would actually be known, which would be needed, which often raises the question, why do we have FB4? It's, can never be fulfilled. But it's an interesting question that even early on when they were devising this worldwide quota system, they gave Asians a much higher number of the visas, and yet it's still not nearly enough. Okay, and then F1 and F3 and F2 really have a small number each divided amongst themselves. And if there are any unused numbers of this 226,000, those numbers go to F2A, which is, remember, spouses and minor children of green card holders. So if there are extra numbers, and there were last year, and they didn't even use all of them, those unused numbers are supposed to go to F2A, spouses and minor children of green card holders. There's also a set aside in F2A without regard to country limits. So there aren't country limits for 77% of the visas that would go to F2A. It's an important number, a significant number. So they're pushing, of those 226,000 that are left over after FB4, F1, and F3, they will be pushed, if there are any numbers left over, to F2A. Now, you may say, well, how can we have numbers left over when we have these long quotas? But remember, it is for the specific year that the visas that we're talking about, using those visas. And the interesting fact is, why did we have so many visas left over in the last 5 years from family-based? Because remember, we got a big boost in the last 3 years of family-based visas that were left, that were not used. They were transferred to, if they weren't used by F2A either, they were transferred to employment-based. Okay, they're transferred across. It's called transferred across to employment-based. Now, why did that happen? Let's look at how people get residency. Most family-based people, other than immediate relatives, as we know, get residency in consulates abroad, right? Most employment-based visas for residency are obtained in the United States through adjustment of status, because people are in status, right? H-1Bs or L-1s or whatever it is, and they can therefore adjust in the United States, much more efficient. Not only that, quite bluntly, Trump destroyed the immigrant visa system at consulates. For those of us who practice in immigration law, you all know the waiting times are ludicrous. It was a combination of what Trump intentionally did, which I believe was to crash the system, COVID, and people leaving the consular service. Those three factors have resulted in ridiculous backlogs, non-processing, and certainly they were hardest hit in the last 3 or 4 or 5 years.
That means that even if there were visas available, there's just not people to process them, right?
Exactly. But it's always been the problem that, as you know, from practicing, adjustment is much more efficient way in the US to get residency than going to a consulate abroad. You have to go to the National Visa Center, you have to present them documents, and it has to go to the consulate. The consulate then, has to have people available to manage it and so forth. So as bad as adjustment may seem often, immigrant visas are far worse. And that, of course, raises substantial issues. And here's the second issue. Why aren't we going to Congress? And this has been a big issue for us at Immigrants List. Why aren't we going to Congress and saying, why don't we do away with 245C2 and 245C8? Because many people who are denied adjustment in the United States are denied because they're not deemed to be in status, especially family, not deemed to be in status, or they have worked unlawfully. If you remove C2 and C8, 245C2 and 245C8, you would have a large number of additional visas, a large number of additional possibilities to adjust status. So that's the second thing, that we have focused on at Immigrants List. We think that that's very important. Okay, so let me turn to employment-based now. Remember, 140,000 visas only, not 226, 140,000 employment-based visas. EB1, 2, and 3 each get 28.6% of those visas. Okay, so EB1 gets 28.6% of the 140, EB2 does, EB3 does. EB4 only gets 7.1%. EB5 only gets 7.1%. So on the employment side, it's not hard numbers, it's percentages. Like for EB5, we always say there's 10,000 visas, but actually it's 7.1%, and sometimes it's 9,900, sometimes it's 99.96 or whatever, but it's not a fixed number, it's a percentage. They can never go below 140,000. And within the employment base, if EB4 is not used, if EB5 is not used, it flows upward to EB1 and then EB2 and EB3, because then it can flow downward from EB1 to EB2 and EB3. Why is this important? Well, I mean, look at EB5 now. You want to file a petition, an I-526 petition, you're waiting for 48 months, they're saying. So the fact is, you wonder, with all this great demand on all these, why aren't they getting done? It's because immigration isn't processing them fast enough to get the visa that year. And therefore, in EB5, it will flow up to EB1. So EB1 will get more visas if EB4 and EB5 are not used. EB4, you know, is generally special immigrant juveniles. There's many categories, but the two primary ones are special immigrant juveniles and religious workers. So if those visas are not used, they flow upward to EB1. If EB1 does not use it, it flows downward to EB2. If EB2 does not use it, it flows downward to EB3. Now, at the end of the year, diversity, as you know, now diversity is separate. If you don't use the visas during the year, you just lose them. They don't go anywhere. So, you know, all this litigation you may be aware of where people sue and it's September, you know, it's October 2nd, it's after the fiscal year, they didn't get their visa, and the courts have said, look, the statute's very clear. You don't get it before September 30th of the fiscal year, you're out.
Wow.
So, yeah.
No, wow. I mean, that just seems unfair, right? You're not entitled, but there's available, but since there's staffing, you almost can pull the string in a certain way if you're a certain administration and say, well, we're not going to give you this sort of staffing for, let's just say, USCIS. Let's see how you do. So you don't have to change. You don't have to change any regulations. You don't have to go through any rule writing. It's a tool if an administration is hostile towards immigration that you can use, which, as you alluded to, Trump did.
Right, and that's absolutely right. And one has to wonder, why did they separately just do this for diversity? I mean, in other words, every other category, if the visa isn't used during the fiscal year, it continues, right? In other words, if you start your case as an EB1 and you don't finish by September 30th of the fiscal year, the visas are still there. Only with diversity do they say, if you don't get it before September 30th, you're out. So that's another issue, depending on how it affects, I think, you know, people from South Asia, you may want to take a look at that. Because there's no real reason for them to say, there's been a lot of litigation, the government's won a lot of it, some of it they've lost, where people filed before and ask a judge to enjoin the government because they didn't act fast enough. It's exactly what you're saying, Rohit, which is, you know, they didn't get around to doing it. Too bad, you know, we didn't have the resources or whatever. So some courts have enjoined them if they bring the lawsuit before September 30th. But in reality, why do we have a separate diversity? If you don't get it, you're out provision, and there's no real reason for it. Now, why hasn't any of this changed is an interesting issue. You know, I'll go through the rest, but one of the reasons you should know is what they call CBO scoring. What is why can't we get changes? Remember when they were trying to bring in a number of immigrant provisions, and they said, well, it won't properly have an economic impact and stuff. All of these desired changes, it's something, you know, particularly if you're going to lobby, you need to know. They're all determined by the Congressional Budget Office scoring process, which is very complex. Very few people know it or understand it. It's all statistically based on numbers, and the government comes back, the CBO comes back every single time when it comes to making changes in immigration, they operate under the assumption that eventually these people who come in will get Obamacare subsidies. And because they will eventually get Obamacare subsidies, that offsets any benefit. Because we always say, right, when we go to Congress, we always say, well, look, if these people come in, they pay taxes, you know, they do all these other things, they contribute to the economy and so forth. And the government's response often is that when they do CBO scoring, that at the end of the day, when they all need, or many of them need, Obamacare subsidies later in life, possibly, that, and this is, I think, more so on the family-based side than the employment-based side, but they say that's why we can't make the changes. Okay. So what happens now? If visas are not used in family-based, they fall across. So if EB1 only, and the same goes the other way. So let's take a case where employment-based, they don't use 140,000, they only use 130,000 that year. The 10,000 goes to F2A, but if there are any left over, okay, I'm sorry. If EB5 only uses 130,000, then there's 10,000 that goes to family-based, but it goes to F2A. Okay, because remember, if there are any unused visas, they'll go to family-based second preference, you know, children, unmarried children, and spouses of residents. If the family-based has extra, they will go to employment. And that's exactly what's happened over the last 3 years. Remember that big boom, all of a sudden we had 280,000 extra employment-based visas. This year we have 57,000 unused family-based visas that are going to go to employment-based, which will mean there'll be approximately 200,000 employment-based visas available. Okay, but here's the catch. Here's why, in a way, this favors employment, but really harms families, or really has no effect. Let's say employment only uses 20,000, okay? Or let's say they only use 40,000, so there's 100,000 extra visas. But when those visas go to family-based, they go toward the 480,000 number. In other words, there is F2A, but they actually go to the 480,000 number. And as we know, it's meaningless. Why? Because if you look at immediate relatives, there may be 600,000 immediate relatives. So even if all those employment-based visas go to family-based, they go toward the 480,000 number, not the 226,000 number. But adding another 100,000 to the 480 has no effect, because there's so many more immigrant, you know, immediate relative petitions than the difference between the 226 and the 480, that it would take hundreds of thousands of visas to make a difference. Now, if there were, then they would go to F2A.
Where does the 7% limitation come in? Is it overall, or is it in each category? Like no one country can get over 7%, which is why.
Yeah, well, we'll get to the. I'm almost there.
Ira, we have half an hour and we have 10 things to cover.
Okay, sorry. Okay, 90% of employment-based people get 245I adjustment in the United States. That's why we don't have many employment-based going to family-based. Family-based, the most immigrant visas, I told you that. Okay, per country limits. And this is something that's important. People scream at me, they say I'm anti-Indian, they get very upset and angry about this. But here's the reality. We've had country limits in the United States since 1917. That's what the national origins quota system was. They separated different countries. They said you only get a certain number of visas and so forth. And it wasn't until 1965, when we had the Civil Rights Act for immigrants, that that was changed. In that system, though, they kept the per country limit, but actually put a number of 20,000 per country. Then they changed it to the 7% that we always talk about in terms of country limits. That was changed in 1990. There are lots of exceptions to the 7%, which people don't know. Even though each country is supposed to get 7%, it only affects a small number of countries, right? We look on the chart, it only affects India, it only affects China, it doesn't affect, most of the rest of the world. And the 7% is limited in two ways. First, it's limited by cross-chargeability, which your client should know, right? I mean that if your spouse is not from India, you may be able to use cross-chargeability and charge it to their quota and be able to get in. So cross-chargeability is a very important aspect to this. The second is, if the category goes unused, and we've seen this quite a bit in EB-5. That's why there were so many Chinese nationals coming in under EB-5, way above the 7%, because if the numbers are unused, then they get the benefit of whatever's left over in that category. Okay, so I'm finished with that. Anybody have any questions, or you want me to? How much time do we have, by the way?
Yeah, 29 minutes.
Oh, why did I have 2:30 to 4:30? Okay. But you know me, I can talk forever. Okay, let me talk about one other thing you raised about layoffs, which I thought people would be interested in. For those of you who have my book, you should look at page 2029 in the volume 2 of the book. It's now in 2 volumes, but it really explains, I thought, quite well about the 60-day. Of course, I would say it explains it quite well, but there's a couple of things you need to know. Obviously, if you get laid off, you look at section 214, 8 CFR 214.1 L2. Okay, and that's the period of stay, the 60-day period of stay. So here's how it works. If your employment ceases, okay, you're given the shorter of 60 days or the end of your original authorized validity. I imagine most people are going to get the full 60 days. The 60 days are intended to be used if employment ends during the approved validity period of the visa. It is not added on. So you don't get an additional 60 days past your visa expiring. You get those 60 days while the visa is there. The purpose of the provision is to give high-skilled workers like Indian nationals, Chinese nationals, people from Southeast Asia, high-skilled workers an opportunity to find other employment or depart, but not to start their own business. Portability is permitted, which is very, very important. In other words, if you find a job, they can port you to that job and start to work right away once they file the application. The period of stay under 214.1L2, the other thing that's important, a person is in any authorized period of this section may apply and be granted any extension of stay, okay, or change of status. So what does that mean? During that 60 days, if you want to be a student, you could change your status to a student. During that 60 days, if you want to extend a status, you can try and do that. And obviously in the case of high-tech people, if they get another job, they're going to want to, and they will be able to eventually extend their status in that category too. I don't know if people have questions about that, but that was the other thing I wanted to mention. Yeah.
So let's just say you got laid off. Going back to the green card, let's say, and if you're Indian, you have a wait, right? If you started the process, let's say ex-employer, what happens to that whole thing?
You mean your residency petition?
Exactly. Yeah.
Right. So I think then the question becomes, is that petition usable with another employer? Generally, there are categories that allow you to use a prior I-140 petition, the priority date
Mhm.
of the prior I-140 petition, which is more important. You may still have to go through the process again. And remember, immigration did a couple of different things over the last year, allowing people to go from EB1 to EB2 or EB2 to EB3 or 3 to 2, so that if you have an adjustment application already pending, you may be able to transfer it. But you can use the original priority date. You may have to file a new I-140 or a new labor cert, depending on the location of the job. If it's in the same statistical area, you may be able to use that labor cert originally and just file for the I-140.
This topic is quite hot. Our Q&A just exploded. Ira, are you able to access that, or do you want me to?
What are your thoughts on laid off workers are unable to find employment to instead seek an EAD for I-140 beneficiaries? Would a layoff be considered compelling?
Is that the humanitarian EAD I'm reading a lot about right now?
Yeah, yes, there is a provision that allows you to do that. It's worth a try. The only thing that always worries me is when people overstay and they don't depart, they jeopardize their future. And given how slow everything is at immigration, not departing, it may be, more than 6 months till you get an answer or whatever, and then you get a negative answer. Now you're subject to the 3-year bar.
Right.
Okay, the second question, if child is born in India and is a citizen of Australia, how will his F2B be processed, sponsored by a parent who's a green card holder? If child is born in India and is a citizen of Australia, can you use cross-chargeability? Is the parent, I guess the question is the parent a citizen of Australia as well? Because then you can use the chargeability of the parent, but the child should be under the Australia quota is the answer. In other words, if the child's born in India, but is a citizen of Australia, you should be able, I think you have to actually, that's a good question, because I think you have to use the citizenship where you were born, but if your parents had Australian citizenship, you may be able to use their cross-chargeability. Okay, 60-day period is allowed every time you are laid off. No, you are allowed to use it if you go back to work and then you're laid off, you can ask for a new 60 days. Do you need a visa stamp or the I-94 and H-1B approval notice is valid? I would try and get the electronic I-94 if you have it. The H-1B approval notice is obviously important, and it should, demonstrate the dates that you were given entry. Remember, this is a status issue. It's not a visa issue. So you're probably going to need the I-94 to prove that you're still in status for more than 60 days. The parents are Australian citizens, I see. Yes, then they can do cross-chargeability and not use the Indian quota and use the Australian quota. Okay, on those.
What happens if you're an Indian citizen, you get laid off, and there's all these countries, Canada, Australia, attracting our skilled workers that don't have status, but their I-140 approved is still in line in the US. Let's say they gain citizenship in Canada or Australia. Are they then still counted? That's what we're talking about? They're still counted by.
Yeah, because it has to do with your nation, where you were born as to how the visas are counted, and not your current citizenship. Okay.
And after a layoff,
For cross chargeability purposes.
Mhm.
What you're asking me is if they have that I-140 pending and it's based on the Indian quota, and they now move to Australia, become a citizen of Australia, but they want to come back to the US, can they rely on their Australian citizenship? I don't know the answer. I think they could. They couldn't do it for cross chargeability, but I think they could for the I-140 if they're now a citizen of Australia.
Hmm.
But I feel a little hesitant to give you a definitive answer on that.
Maybe the next volume, maybe the next volume.
yes.
Yeah, send me the questions in advance, then I'd sound intelligent. Oh, okay, so let's talk about, what you can do in terms of lobbying. And here's my idea. I kept thinking about this because I know we talked about it before. I think the Eagle Act is not going to go anywhere. And I think the Eagle Act is not going to go anywhere.
What is the Eagle Act? Do you mind like a minute if anyone doesn't know, including me myself?
Oh, I'm sorry. Okay. The Eagle Act came up, and this is something that, the high-tech community has been promising really the Indian community for years after recruiting everybody from India. And then realizing they had a problem, they've been trying to push this bill. And the bill basically ends the quotas, right? And ends the country limitations. And, from a fairness point of view of what's happened to Indians, it's outrageous. The government should do something about it. From the point of view of why do we have quotas for countries anyway? In a way, it's a vestige of the national origins quota system. All of that are good arguments. The problem is, and this is my very strong feeling, because to me, this has to do with lots of problems in the US, which is you get some powerful group like the high-tech industry. And what are they really doing? They're pitting Indians against the rest of the world. They're saying, okay, we want to give this benefit to Indians, and we don't care really what happens to anyone else. Because if you lift the quota instead of just providing more numbers, in other words, if they really want to solve this problem, they can solve this problem in the way that it was proposed in 2012, which is to get more numbers, more visa numbers, and the counting of derivatives. Don't pit the rest of the world or Indians against the rest of the world, or the rest of the world against Indians, because that's what the Eagle Act ultimately does. It ultimately says, we're going to lift these country quotas, which sounds like a fair idea, but the consequence is it basically harms everybody else for years and years and years in every other field. I mean, in other words, maybe to help some people in medical fields, but basically it's designed to help the high-tech industry. And this would stop, somebody who may have, as I tell my grandchildren, invent the anti-gravity machine, and so rocket scientists can't come in, others can't come in if they're not, if they are not coming from India. So it blocks out not only pits Indians against everybody else, it blocks out the ability of others to come in to make important contributions to the US. And there's a simple solution. Give us more visas. Don't count derivatives. Okay, why are you pitting Indians against everybody else? And all this stuff, I used to get calls, you're a racist, you're this and that. I started my career as a civil rights lawyer, so it did bother me a little bit. But, this is not an issue of racism, it's an issue of fairness.
I would even think if like the Eagle Act bill was enacted, and let's just say Indians got a disappoint more than and affected other nationalities, there might be even a practical, real effect in backlash towards Indians and Indian workers within the community. Then you have people from other countries saying, well, I can't get a visa now because of you. And it's unfair. Where it's not the Indian, it's the system. It's an economic system, I think, that is not, the immigration system is not built for our economic system.
Right, and the well, yeah, that's right. If we had a rational system, we would be looking at this every 5 years. Since 1990 was the last time we
30 years ago.
32 years ago, 33. And if we had a rational system, you would be looking at it every 5 years. How do we calibrate it? We need more visas in this category. Maybe we don't need as many in others.
Right.
But, it's become, even, especially now, even with 10.5 million jobs that are still available in the US, it's become a political football. And I think the way to deal with this my final thoughts here about it, in my view, the way to deal with this is the CHIPS Act, because the CHIPS Act had strong bipartisan support. The person who really engineered the CHIPS Act, and you should really get a lot of credit for it, is Maria Cantwell, the senator from the state of Washington. We know, at least articles have now written, that as a result of the CHIPS Act, we will need 20,000 to 30,000 new jobs will be available. And if we can't get those jobs, they're not going to be successful in doing what they're trying to do, which is to bring back the manufacturing of chips to the United States, because we regard it as a national security issue. And it's one of the bills that actually got bipartisan support, because Republicans, as much as they don't want to help immigrants, right, recognize that, and the bill wasn't designed to do anything with immigration, actually. The bill is designed to just bring chip manufacturing back to the US and do a bunch of other things, and doesn't have immigration provisions in it. But this is a way of saying, look, we overlook this. 20,000, 30,000 visas people are going to be needed to do these jobs. We don't have the capacity to have those people in the United States do these jobs, because, and to the extent there's a backlog, why don't we start either not counting derivatives or issuing more and more visas so we can attract more people to do what amounts to a national security issue. And I think if you tie it in those terms, Republicans are going to be hard pressed to oppose it. Doesn't mean they won't, but I think you have a new argument, it seems to me, than just going to them, kind of hat in hand and saying, well, we have all these backlogs. It's a big problem, because obviously they haven't cared about it for 33 years. They're not necessarily going to care about it now. But I think the way to do it is to talk about national security, what we need in the CHIPS Act. We're going to need 20 to 30,000 new employees, or 20 or 30,000 existing employees. Indian nationals, Chinese nationals are leaving the country because they don't want to have a 15-year wait, 20-year wait. How are we attracting those people to come in? We don't have the people to do it here. We just don't. So I think that's, and you got to get the statistics and all the information. But I think Cantwell is a very, very smart, very intelligent person. Immigration isn't necessarily her issue, but it's one of those things where you may want to ask her for help. How do we implement? They have to implement the CHIPS Act. Part of that implementation is not just, doing the infrastructure, right? Part of it is who's going to do it.
Right.
Who's going to do the work. So
Do you think that's going to be persuasive? I mean, number one, national security, of course, is important, but like over the last year or two, labor shortages, it's a simple solution. You increase the visa numbers, right? Like H-2B, they authorized a little bit more, right? But there's a huge labor shortage right now. I mean, not even for skilled. What are you going to do about the unskilled? Huge demand. I mean, this morning there was like an email for, there's no bus drivers in our school district. Everyone has to take their kid to school.
Yeah, I had a long conversation with the place I often go to lunch. She said she had to close one of her places. She couldn't find people to do the job. I mean, in the food industry, and in a lot of these lower skilled jobs, there are no people. I mean, there's no question about it. But how do you get them to do anything about that when they have said we're not going to issue more visas? CHIP seems to me to be at least an angle where you can talk about national security. But yeah, I mean, in terms of lobbying, I mean, if you wanted to do that kind of lobbying, you bring the employers with you who will say, we have no people to do this work. I mean, the most effective lobbying is bringing people from the constituency of the member to make an appointment to say, look, I'm in dire straits. We need to do something. And you be there with the answer. Here's how we do it.
Yeah.
Here's what you need to do. So you have the employers coming and saying they have a problem, and you're our member, you're our senator, you're our House of Representatives member, and try and find the key people. It's a little vague right now on the House side because nobody seems to know what the heck is going on. But on the Senate side, there are people very clearly on the, Department of Homeland Security Committee. The Dick Durbin he may still be the head of the immigration subcommittee. You need they'll tell you, well, you got to get the House, which is true. But if they're on board and they can start raising this as an issue, and I think by your going, the other thing you're doing is you're sort of putting it to the Democrats, because the Democrats really are not that pro-immigration in my view. They are much, much, much better than the Republicans, but so you got to push them. And the way that you push them is say, it's not an excuse to tell us, look to the House. You should be making the issue of the lack of employees in the United States and the fact that Indians and Chinese are leaving the United States, high-skilled people are leaving because of these. You need to beat the drum because, I mean, think about it. The anti-immigrant crowd has always hid behind, they're going to take your job away. Mm-hmm. They don't have that argument now. And you want to pound them over the head with that. Because what is their argument now? It's just naked racism.
Yeah, I mean,
that's what it is.
Yeah, I think to a certain extent, we've talked about the green cards and the lack of availability and years of wait. Second part of that is the H-1B system. For Indians coming to work here, that's kind of the main pipeline, and it's a lottery. Right. And I'm sure I represent clients that are desperately trying to hang on to these employees that are Indian or Chinese or different nationalities that they can't. There's no system that they can hang on. And I think posing it as an economic solution rather than, and let's face it, immigration, the first laws is kind of an economic solution to kind of get people in, right? To a certain extent, that's what it needs to be posed as you're talking about, Ira.
Yeah, no, I agree completely. But I think you've got two big weapons now. One is there is a chronic labor shortage, and you should force the Democrats to make that the issue of bringing people to do jobs under, fair conditions and so forth, because the Democrats are much more concerned about not just bringing low skilled, low wage, but, bringing in people who will get the benefit of a higher wage and so forth and will be protected. But, I would go after them on the Democratic side, and on the Republican side, basically go to them and say, look, we need workers, and bring the employers with you if you can. And I just think the Eagle Act is not going to get passed. I think there's too much opposition. There's too much feeling this is discriminatory for everybody. I know how Indian nationals feel about it. They feel very, very strongly about it. But many other people are looking at it like, no, this is discriminating against us because you will have all the visas. And that's a tough argument to overcome.
Sorry.
Yeah. No, I was just gonna say, I think the answer is more visas, more visas, more visas. I think that's what we gotta find, just a constant pounding on them. The answer is more visas. It's been more visas for 33 years. The
Mhm.
Republicans refused to issue one more visa. And look at our country, it's in shambles. We can't find people to work. We can't pick out crops. We have huge backlogs for people in the high-tech industry, all that.
Yep, and another kind of touch on it a little bit where kids of these immigrants have been affected because after 21 years old, what happens? Do they have
Right,
an option? They
right,
gotta,
right.
so if the wait is 15, 20 years, and if you have a child who's 10 years old, at 21, they don't have an option for a green card.
Right.
If you're an Indian national, it seems crazy.
Yeah, no, I mean, I think that's right. I think the fact that they have put people in this box now, you can always tinker around with these things, right? Early adjustment, which is one of the things they were talking about, just allow people to adjust, file their adjustments, but to address your concern, say under the Child Status Protection Act, since they filed, they can age out. But these are all workarounds to the thing that's staring them right in the face. We just need more visas. We're not the same country we were 33 years ago. And we can target them and figure out how to do that and so forth, but we need more visas, we need more workers coming into the United States. Else we're going to wind up, like Japan, we'll have a stagflation for 25 years. The population in the US is getting older, right? I mean, they need people immigrating to the United States. So
We have a question, Mala. Should we get those before we have 3 minutes? Or
sorry about that, guys.
no, amazing.
You
Thank
should
you so
never
much.
have me on and say to me I can talk the whole time, because I will.
Is it, I mean, I don't know asylum law very well, but is it like if you filed under your parents, then even if you age out, you still have status? Is that something that can be brought into this employment situation with like H-1Bs from India, huge backlog? These children we have this crisis called documented dreamers, right? Like the DACAs of South Asia. So is
Right.
that a small workaround when we're dealing with a very strong anti-immigrant stand? Yeah.
Yeah, I mean, I think they can say that, once you file, and that may be an administrative change that they may be able to do, although the statutes does say asylum, upon filing. But, they have this complicated formula for employment based and, for family based, how long the petition's been pending, deduct that time from the person's age. They can just say, when the family files, everybody is protected.
Yes,
Period.
exactly. And that's just an American value, right? I mean, it's family unity, it's children. It has nothing to do with politics. It's just a human.
Right. Right. And sometimes they're more sympathetic to that because the kids really had no control over it, right?
So we are running out of time. We just have 2 minutes left on it. We know we have a few questions, but Ira, is there anything that you want to kind of close with, or Rohit?
I think we're at a very different position today with the vast numbers of jobs that are unfulfilled in a whole variety of industries, with the need to develop and bring back to the United States what amounts to high-tech jobs because of the CHIPS Act, the infrastructure projects. In other words, I think we have to find a way to articulate that all of these things that are going forward, the green revolution, these other things require high-skilled people to do part of the work. They may also require low skill, but they certainly require high skill. We don't have the people. I mean, I read an article yesterday about the EPA. The EPA can't even get out regulations because they don't have the people to do it. So we're in a very different situation than we were 10 years ago or even 5 years ago. And I think we got to get the country to wake up to that. I think that's the goal. You know, everybody kind of knows it. You go into a restaurant and there's not enough people there, or you go into a supermarket, there's nobody to work. You know, people know it intuitively, but we've got to turn it around to say, this is about immigration.
Yeah.
We got to get the Democrats to have a little bit more nerve to say that's what it's about.
Awesome. Thank you.
Hi, everyone. I guess we're ending our 1 hour time period and don't want to take too much more time from Ira. Thank you, Ira, for
Thank
all
you
of
so
your
much.
knowledge and all the things that you do and letting us know how to keep the dream alive.
All right.
And we'll be calling upon you in the next few weeks, months, so we can frame our agenda for Lobby Week. And thank you to Mala and Rohit for ably getting us through this presentation and taking this issue forward into the next couple months. Thank you.
Thank you all. And Immigrants List is happy to help, you know, on lobbying week. So give us a call. Let us know.
We will. We will. Thank you. Bye.
Take care.
Thanks, everyone.
Bye.